All right, good morning, everyone. This is our real estate town hall. My name is Barry Miller, president of the closing agent and attorney with Barry Miller Law. Thank you for joining us today. These are quite trying times with a lot of intricacies of the real estate industry, and we're having this town hall today to answer your questions, inform you what's going on, and take your questions. And we've got our great panel today. I want to introduce, first we got David Berman.
Good morning.
Robert Garcia.
Good morning.
Go over here, Casey Scalise.
Good morning.
And Christian Walters.
Good morning.
So what we're going to do today, just to set the agenda, we're going to talk about different subjects. First, we're going to talk about the new executive order that the mayor of Orange County issued and how it affects the real estate industry. We'll have a discussion on that. Then we're going to talk about powers of attorney and how you can utilize those to make sure your closings move forward. Then we're going to talk about RON, remote online notarization, online closings, which we've been doing a lot these days. Then we're going to talk about the contract in force majeure and how that affects you, and I imagine a lot of you are going to have questions on this. Then we're going to talk about addendums. We're going to talk about the FAR addendum that was put out, and then about our addendum that we drafted and came up with even before they came out with theirs. Then we've also designed a broker disclosure directive, and that's these documents, by the way, are on our website for you to download. And then we're going to talk about the importance in these times of having healthcare surrogates and estate planning. And then we'll also talk about evictions and how that's impacted with the orders that have been issued in the policy by the different sheriff's office of not enforcing writs and what you should do and what you can't do. So first, let's talk about the order that was issued last night at 5 o'clock. It's an Orange County Emergency Executive Order 2020-04. So the good news is that under Provision 20, legal or accounting services and notaries public are exempt. We're considered essential personnel. So under that provision, we can continue to do closings. If you're doing banks and related financial institutions can stay open. Licensed contractors, tradesmen, appliance repair personnel, for those you do property management, under paragraph 10 can remain doing business. Also under paragraph 21 is exemption for maintenance of property. So I think those of you involved with property management can continue doing business. However, under this order, it does not appear that real estate agent activity is exempt. Hopefully no one is doing open houses. We don't recommend you do that at this time. Now, one of the nice things I know some of the agents are doing are virtual open houses, where you do something like this, Facebook Live, and you can show prospective buyers the properties. But now under this provision, I don't believe that you could even do that, but we can go into a discussion. So let's first talk a little bit about do's and don'ts of this order, because the other thing that's not on here is property inspections. So home inspections do not appear to be exempt. We'll discuss that right now. And then also appraisals. Appraisers are not on here. So let's open up the floor to the discussion on the impact of this order that just happened at 5 o'clock. Many of us just had a chance, less than a day to go over it. So how do we suggest that the agents, if you've got an inspection coming up, how do we suggest that agents deal with this? Now, one of the big things too is with force majeure, we're going to talk over this too. Our whole goal on here is to set this forth as a roadmap to resolution, because we don't want deals and these transactions to cancel, but we want to figure out a way that's a win-win for both sides. So, and the whole thing is a roadmap for resolution, and let's talk about how we can do that. All right, so let's start out. How do we handle, guys, inspections? So how the inspections say they're not coming out. What's a resolution for that we can do?
So first and foremost, there's an interesting ambiguity under the contract arising with respect to the inspection contingency of the contract. There's nothing that actually requires in any way, shape, or form that someone actually get a home inspector. It just provides that the buyer has a duration of time to perform inspections that they deem reasonable or necessary in their own discretion. That being said, the force majeure provision, which we'll get into a little bit later, does provide some guidance. Unfortunately, it is a little bit ambiguous in its interpretation, perhaps even its application, but potentially that might be an out as well, or at least an ability to reach a resolution via extending the inspection or so on.
Well, I think the easiest way for us to do that is to just go through our inspection addendum that we've drafted for this situation so that we keep the transactions moving forward, because we wanted to make sure these deals go forward for our agents and for our clients and customers. So we have an addendum drafted already that addresses this issue for our agents. So they contact the law firm, we are able to provide them with that addendum to no charge.
Yes, it's posted on the website. So of course, the first thing is see if the parties will agree to extend it. But Christian, on those lines, yes, it's not an essential service under force majeure. However, it is a right under the contract. So let's say to take your argument a little bit further on that, yes, you can self-inspect. But now under the executive order, I can't even go out to the house to self-inspect. Does it now become impossibility and then fall under the common law that you're going to talk about a little bit? So it could come under that. This is very fluid because we're just coming up with this right now.
Interestingly enough, I think it would. If a buyer's ability to access the property to perform a self-inspection is delayed or disrupted as a result of the executive order or really any governmental regulation with respect to coronavirus, then yes, I do think that would be covered by the force majeure provision, which would delay closing for a time period we'll talk about in a little bit.
Great. Anyone else?
Well, I think at the end of the day, it's removing any ambiguity and communicating between all the parties in a reasonable manner, just to set expectations and to make sure everyone is on the same page.
Okay, so good. So send in your questions, and then we'll try to get to them. We're going to go through some of the material at first. So first, we're going to talk about a power of attorney. So obviously, you're going to have a buyer or seller that may not be able to come in because it is an exemption now to come in if they want to, but maybe they don't feel comfortable coming in, or what we've had a lot of people is they're out of state. So we had let me tell you two that I've done last week. One I had, they were both out of the country, U.S. citizens that couldn't make it back. So they gave us a power of attorney so that we could close. So let's discuss, and Robert's going to talk all the aspects of a POA, what it is, how it can work, and how it can make that real estate closing happen.
Yeah. Hey, thank you, Barry. Yeah, we've received a lot of calls and questions coming from our agents and buyers and sellers about alternative ways for us to do these closings. They don't want to be here, or like Barry said, there's travel restrictions now in place, which are making it more difficult to get to our offices to do the closing. There are different ways that we can go forward with the closing for our clients. One way Barry's going to talk about is RON, the remote online notarization. But an alternative way for an in-person closing is through a limited power of attorney. And here's a sample of it. We have it, I believe, posted as well. If not, contact us. One of the great things about the limited power of attorney is that it's, first of all, can be used by both the buyer and seller during a transaction. And when we say the limited power of attorney is, we have tailored it for our clients so there's no ambiguity, that they're giving us the power and the authority to sign their closing documents solely for the subject property at issue. It's not going to be used for any other purposes, and it's expressly set in there, black and white. And we made it very simple for our clients because we kept it down to a page. So one of the great things, again, is it's limited solely to a single transaction, can be used by both your buyers or sellers. Now, if you're on the buyer's side, we need you guys to notify us a day or two beforehand because we need the lenders to amend their documents to reflect that John Doe will be signing the documents as the attorney, in fact, for the buyer. So we want to have those documents at least, preferably, 1 to 2 days before closing.
Well, and also on that is most lenders, we have to submit the power of attorney to them for approval. And I can tell you from doing this for 37 years, they always approve ours, but it's a formality that it has to be submitted. So really 48 hours would be better just to submit it to them. A lot of the lenders are working remotely, and we just got to get them into them. So, Robert, who do they give the power of attorney to?
Well, there's two options right now. The first option that we prefer is we have drafted the power of attorney. Again, it's a limited power of attorney, strictly to be given to 2 of the attorneys here at the law firm. So in case one of the attorneys is unavailable in the court proceeding or have a family matter, there's someone else there to close your documents, to sign on your behalf. Most power of attorneys normally give it to one person. In this situation, we decided to be creative to make sure your transaction closes. So we have given the power to 2 people, option A or option B, one of 2 attorneys. But there may be situations where you don't want to give it to me, you don't want to give it to you, Barry, as the attorney in fact, the person with the authority to sign on your behalf. If that's the case, feel free to give it to a family member or to a friend. But we recommend, again, that you have at least 2 people on the power of attorneys, because people are now being held up with shelters in place, stay-at-home orders, some people are getting sick. So we want to make sure your transaction closes. So if you are going to use the limited power of attorney, please identify 2 individuals that you have confidence with that can sign the documents on your behalf. Another great thing is with the closing agent is there is no charge for the limited power of attorney. Other title companies, some law firms are charging for it. We don't. We provide it as a benefit to our clients and our customers because we think it's important that these transactions closes. And one of the last things I want to say is it's a durable power of attorney and why that is important. If the individual signing the power of attorney, the buyer or seller, becomes incapacitated, let's say they get sick, let's say they get the coronavirus, or they just have a stroke or a heart attack, for whatever medical reason they become incapacitated, the power of attorney is still in place and it's still viable, so the transaction can close. It's for everyone's benefit right now. It's for the sellers, it's for the buyers, it's for you agents out there to make sure your transaction closes.
And one other thing on that with the POAs and people coming to closing, whether it's the person you give it or your buyer or seller, since we do have the this stay-at-home order from Orange County, we will be having a letter that your processor can give you that so that if you get stopped on the way, we don't know how much they're going to be enforcing this, but if for some reason you get stopped and they say, where are you going? We'll have a letter you could show the law enforcement officer that say, I'm going to a real estate closing that is exempt under the order, and therefore let me proceed, and they won't issue you a fine. So that will have a form letter for you, so don't worry about that. We don't want people getting anxiety about thinking they're going to get stopped on the way, and if you do, you'll have that letter. We fine. We don't want anyone abusing it either, so you'll show the time and date of when it is. So thank you for that, and that's a great option to use for people. So next I'm going to talk about RON, Remote Online Notarization. So that became a reality in Florida January 1st. I happen to have been the first remote online notary authorized by the state. We did the first one on January 7th. I've been doing a lot of them lately. Did one yesterday that the U.S. citizens were stuck in Honduras. So here's the good and here's the bad. If it's on the seller side, it can be done. If it's on the buyer side and it's cash, it can be done. If there is a lender, there's really only a couple of lenders that will allow a full RON closing. That's why the POA is the best alternative. The main reason is because the promissory note is a negotiable instrument. And without a wet signature on there, there's enforcement issues on it. The couple of lenders that have done it, they have protocols in place where the electronic signature is then immediately transferred to what they call an e-vault for legal purposes, so when there's enforcement later, it can be used and introduced into evidence. Because under Florida law, the original note is to be deposited and given to the clerk of the court as part of the foreclosure. So under the e-vault or the digital vault, it can be done. Most lenders aren't set up for this. So we can get some people to sign a power of attorney if they're a buyer, giving one of us so we can sign it. And by the way, if one of us is the power of attorney, we will go over the documents on the phone with the client beforehand. We're not going to blanketly sign them. They'll be emailed all the documents, reviewed them. If they have any questions, just like in a closing. We go over documents here, we explain them. So that's a good alternative that we're on. Now the other challenge is this. The person has to be authenticated. So to do that, it's called KBA. Probably some of you have been done that with your bank or somewhere else, where they ask you 5 questions, you got to answer it. What was the color of your first car? Did you ever own one of these cars? What street did you grow up on? So they pull this from credit sources. So the problem is, if you're not a U.S. citizen and you don't have credit, you can't get qualified. Now, I did do a gentleman last week. He's a resident of China. He's a Chinese citizen. How did we do it? He had a TIN number, a tax ID number, and he had credit here in the U.S. So if they are a foreigner and have those 2 things, we can try to authenticate them. So that's going to be a good alternative. So again, it's fluid, it's moving. There is a bill in Congress right now to give some more leeway on this. However, one of the things I read is even if that one passes, it's still going to be subject to state law. So I don't think it's really going to change or loosen up those requirements. So it's an alternative, but it's a limited alternative. All right, so let's talk now about force majeure.
Sure. So just to clarify some of the comments made at the opening of the presentation, the bulk of what I'll be talking about today with respect to force majeure is going to concern the as-is contract. The residential contract operates a little bit differently with respect to inspections. The as-is contract does not basically say that you're required to get an inspection. It's such inspections as the buyer deems reasonable. Whereas under the residential contract, the buyer does have a set forth right to get an actual licensed home inspector to approve the property. In that instance, the unavailability of a home inspector under the regular residential contract can constitute a force majeure, as the case may be, to extend the closing date. Now, the bulk of what we're going to be talking about for the remainder, like I said, is going to focus on the as-is. For those of you that haven't had a chance yet to see it, if you go to theclosingagent.com, there is a link on the closing agent's website. It's listed under the COVID-19 Realtor Education Center. We have all the documents that we're talking about today posted on that webpage, in addition to a blog post which our attorneys prepared, which will run you through typical scenarios using the force majeure provision in the as-is contract. There are 2 methods that the force majeure provision is triggered by. It's the inability to perform an obligation under the contract due to a delay, disruption, so on, resulting from coronavirus. The second is the non-availability of services essential to closing. These would be the title agents actually closed, or the bank's not issuing wires, or the bank closed in its entirety and therefore can't enter a funding approval, or things of that nature. That would trigger these provisions. So what happens when this provision is triggered? In essence, closing will be delayed up to 7 days after the force majeure no longer prevents performance. So what that means is once, let's say, the bank stops funding and won't issue a funding approval, that force majeure will kick in and extend closing up to 7 days past when the bank begins funding again, up to a maximum of 30 days past the closing date. After that 30 days, either party can cancel and the buyer can get their deposit back. That being said, I'd like to turn it back to Barry to discuss some potential exact scenarios which might happen.
So let's go ahead and break up the topics here, and let's take a couple of questions. First one from Jennifer Van Loon. I have a closing on Friday morning. Seller is a mail away and buyer is scheduled to sign at 9 a.m. Friday. Is there any reason to believe this will not be possible? What needs to be done? It is possible. It should happen. Anyone? Well, I think we're good.
Yeah, one of the exemptions is businesses providing mailing and shipping services. So as far as the mail away, that shouldn't be any issue.
Yeah, so everything should be fine with that. The party that's gonna come in can come in and sign the mail away. You know, if they're gonna say not availability, they can't get a notary, well, notary services are an exemption, and I don't know where that mail away person is. Okay, Bridget Basil, Day, we have a walkthrough on your listing on April 9th in Lake County at 9:15 and closing at 10:30 in Orlando. So I can't attend any of these as listing agent. Okay, so the walkthrough in Lake County you can do because Lake County, as of right now, as far as I know, does not have a stay-in-place order. So do you guys agree she could attend that?
I think
Now,
the gist of the question would be, can they leave from their home in Orlando
That's
to
what-
attend the closing
right.
or to attend the walkthrough in Lake County?
Right, so that's the issue here. Technically, probably not. Now, realistically, are you gonna get stopped going there? I don't know how close you are there. So you probably can't. So see what I would suggest is, because I encourage you to, you know, obey the order from the mayor. So here's the alternative. Have your client go and do the walkthrough, have them have their phone and have it on so you can go and do the walkthrough visually with them remotely, and then they can come here. Now, since realtors cannot come to closings under this order, agreed?
Correct.
Then what do we do? Because it's important for you to be there. So what we're gonna do is you can attend by phone, speakerphone, or you know, we can use FaceTime or an alternative source so you can visually be there. So that's an alternate too. So if you want to attend by that way, let your processor closer here know. We'll be glad to accommodate that. Okay, next one, Courtney O'Brien. I have an FHA closing on April 3rd. Will still require a wet signature? Yes, they will require on those wet signatures. So one other comment that David, you wanted to add in on
With the Lake County closing on the 9th, now
Right.
currently the order that is in place expires at 11 p.m. on April 9th. It's possible you can agree to a one-day extension. Obviously, this order is subject to change, but at the current time, this expires April 9th. So again, if you can get a one-day extension, you may resolve your issue.
Okay, so that's a great alternative. Is there other questions?
That's the last one.
Okay, all right, so keep your questions coming in if you want, and we'll do that. All right, so now, Casey, let's talk about the addendum. First, let's talk, because the Florida Association of Realtors came out with an addendum, and just so realize people, it's not a FAR bar. The bar hasn't endorsed it. It doesn't have the legal backing there, and we're going to go through why we think you should use ours instead.
Right. So before FAR released their extension addendum, we created a little addendum of our own. We see some issues with the FAR extension addendum, such as it's designed to use with the vacant land contract, the commercial contract, as well as the as-is contract. So it includes things, dates and time periods that we don't use in the as-is contract. That can open the possibility of adding confusion or other complications to the deal.
So give us an example of like one of the things that's in there that is not in the regular contract or in the as-is contract that's strictly towards commercial.
Right. So the feasibility study period, I don't believe there's a due diligence period in the as-is contract. So things like this we could confuse with, say, the inspection period, and then we may check, the wrong box and we don't extend the right thing.
So it's going to create a problem if someone, instead of checks the box extending the inspection period and wrongly puts a due diligence period, is there really going to be an extension? Because you extended something that doesn't even exist in the contract. So play it safe, folks. Just use the one we have on there. It's designed for the FAR bar contract, and it will be good to use. What other things on there?
So the FAR extension addendum contains language regarding the dates if they have not yet passed or expired. If someone tries to extend a period that has already expired through this addendum, we're going to have conflicting documents related to the contract, and that's just going to add more confusion and difficulty to this deal. Another thing is it includes language conditioning periods on the lender refusing to fund the loan due to COVID. That's very vague, and we're not exactly sure what they're trying to convey here. So all in all, use our extension addendum. It's very simple, it's very brief and clear, which is what we're going for.
So while I have Barry here, presumably this presentation will be available online after.
Yes, so
On
if
Facebook
anyone had
page.
any issues, because I heard some people with desktops or that Facebook is having some issues.
We're good now.
Yeah, it's good now, but the whole thing will be recorded and posted, so if anyone needs it. So again, the bottom part of the FAR language, it's just so generic. It's opened up for different types of interpretation. It's going to cause confusion. So, you know, what does it have in here about if the lender doesn't fund? It's just vague. Let's be concise so we don't have problems down the road.
So to resolve any unclearness, we have created our own addendum. I see a bunch of you guys asking in the chat whether or not just use the regular extension addendum. We have one, and that is available on our website, theclosingagent.com, again, in the COVID-19 Resource Center.
Right, so we've designed one. It's all on there, easy to use. And again, this is the roadmap on here to resolution. This is going to resolve it, and with no problems, no questions, and great stuff like that. Okay, so the next thing we're going to talk about is a broker disclosure and directive. Now, this is another document that is on our website. So what this is, it's a notice, and it goes through, and we recommend using this, that the seller understands. Now, once we get back up, because right now we can't be, not going to be showing any properties, but take a look at this document, because it does show on there, and it does have on there that they understand about the viruses out there. They're going to be, it talks about marketing activities, and then it authorizes them or says to a person, once we're back up and running, whether or not to do open houses. But another thing that's very important on there, we built in an extension for your listing agreement. So I think it's fair to go to some of your sellers and say, because we haven't been able to market and show your property, we'd like to have an extension. Christian, you helped mainly draft it on this document. Anything else to add on that?
With respect to the broker disclosure, it contains a simple release of liability in the event, assuming, of course, the emergency stay-at-home order is lifted or expired at the time. But it does contain a release of liability. Obviously, real estate agents aren't doctors. You guys can't take the temperature of everyone walking into an open house to make sure they have corona. There is some evidence to suggest that corona does remain on surfaces for a period of time. Obviously, if someone's asymptomatic coming into a home, coughs on a surface, that's seller occupied, a seller might get corona and then attempt to allege you were negligent in some way, shape, or form by allowing someone who was exposed or infected into the home to complete a showing. And this basically releases and absolves agents of liability arising because of that circumstance.
So I would suggest try to use this with your existing, and that if you're taking any new listings, make this part of your package. Now, of course, for all of our clients that are in the other counties other than Orange, down in Osceola, Brevard, Lake, Seminole, Volusia, because we call, and down in Polk County, use that part of there now, and be careful now when you're showing property. And I would recommend you use this. It's a safety guard. We want to protect you. We don't want to have claims against you and someone saying, I got the virus because you showed the house, or allowed someone to show the house that potentially has it. We don't need that.
Also, the disclosure does contain a consent between the agent and the seller to define or really limit the scope of services, marketing activities and marketing services to be provided by the agent with respect to the listing agreement. Basically, it contains checkboxes that allow the seller and the real estate agent to agree that the listing agent will not perform this service, such as open houses, but will perform these services, so on and so forth. So it clarifies a relationship and sets forth in writing what the seller will request that the agent performs, and similarly what the agent will not be performing as a result of this epidemic.
Great. Okay, so we are going to take questions, so go ahead and type your questions in on there. So a little bit off of your own protection and things going on, I'm going to have David talk a little bit about healthcare surrogates and estate planning. All of you, do you have wills? Do you have a general power of attorney? Do you have someone to designate your as a healthcare surrogate? All that stuff is important.
So my comments today are going to be valid at any time. They're just a little bit more of a priority at this time for obvious reasons. Some of the things, and many of you that work with us know, we prepare will packages that includes multiple documents, including a will, durable power of attorney, healthcare surrogate, and living will, among other documents. We're now doing individual documents, and we can prepare those on a separate basis. A couple of the ones I want to speak about specifically are living wills and designation of healthcare surrogates. A living will is the document where a person directs medical facilities and medical providers what they want done in the event that person becomes incapacitated, meaning whether or not they want life-prolonging procedures. This could be if you are in a accident or you have a end-of-life stage condition, whether you want extensive life-prolonging activities performed upon you. Obviously, everyone has their ability to make that direction to the medical providers prior or in advance of any situation arising. In combination with that is a designation of healthcare surrogate. This is similar to a power of attorney or otherwise a healthcare power of attorney. It's where someone nominates another to make a medical decision on your behalf in the event, again, you're incapacitated and unable to make those decisions on your own. Just to sort of assuage some concerns, for these documents to be effective, there has to be two medical professionals to make a determination that the person is incapacitated or has an end-stage condition. So if you have a child and you think they're just, you stub your toe and you think they're going to pull the plug on you, it's not effective in that event. These are truly for those situations where you cannot make a decision. Obviously, there is a heaviness or considerable thought that goes into these documents because the person that is making these decisions has a heavy decision to make. Again, part of the reason why we use these in combination is when you do the living will, it also gives your surrogate direction and can make a decision or make their decision a bit easier. It can remove the stress and anxiety involved with having to make medical decisions in critical times. As Barry said, some of the other issues some of the other documents that we work with are wills, simple estates. We can also prepare trusts and land trusts. So again, in these times, obviously, we're proceeding with real estate closings, and there are ways that we can assist with doing this from an estate planning perspective. Land trusts and trusts are a great way to do this. One other item I want to specifically address because it's of utmost importance. A number of people call and say they have a will done either out of state or they've looked at online sources or they've gone to a local store, an office supply store like Office Depot, and purchased a will there. The number of wills that I have seen that are either done out of state or prepared by a national vendor that do not comply with Florida law is astounding. This is why it is so important to consult an attorney that handles these on a regular basis. You don't want to have something happen to you. You feel like you're fully protected, your estate is going to be administered in accordance with your wishes, only to find out your documents were not properly executed in accordance with Florida will. These are strict compliance documents, meaning under Florida statutes, a court will not give your documents validity in the state, and therefore your wishes will not be granted in accordance under Florida law. So, with regard to the living will and designation of healthcare surrogates, these require 2 witnesses. Other estate documents often require at least 2 witnesses signed in the presence of each other with notaries. This is something that a legal provider, our firm, can provide for you. And again, it is vital to have your documents properly prepared and properly executed, because in the event they are not, they will not be deemed valid and your wishes will not be met.
All right, that's great. And unfortunately, we've seen this, and I especially one horrific story is I had a senior citizen that did one of those online, $99 do your whole will package, and it fills in the blank. She didn't understand it, did it wrong. She ended up in the will giving her entire estate to someone she intended to exclude. And the family tried to fight it, and the court said, we don't have a choice. It's in there, it was there, so it's just horrific on there.
Very real quick. One other matter that I'm addressing at the moment, similar to what Barry said, this was a will that wasn't properly executed. Obviously, what Barry said, the possibility of your assets going to people you did not intend. The other issue is the time and cost associated with sorting this out. Much of your estate can be eaten up just through the administration cost and time. So again, take the time up front to prepare the documents properly to avoid the cost and anxiety that your loved ones will face if you don't take just those few additional minutes to do it properly up front.
Great. Thank you, David. Now, one of the other questions came up, it's a great question, is, okay, so now we've closed, how are we going to move into our new house? Can the movers move in? So under number 25 of the exemption under the order, it does exclude trucking. So movers, logistic providers, so movers will be able to move the buyer into their new home. So that's good news. Now, great question from Nitsa that came in on here, addressing new construction and buyers' rights to extend deposits due. As a matter of fact, we just had this yesterday that a client came in and sent over. So maybe let's have a little discussion on that, because we do have so much new construction. I would hope these builders would be cooperative and working with people on this, but unfortunately, this is one of the things we've been preaching about for years. Those 60-page new home contracts, which everyone says they won't change a word on it, that's true, but we've negotiated addendums on there to make it better, and we explain them. No one explains them. You as realtors cannot explain them. When the realtor says, what does this provision mean? You can't tell them. That's practicing law. That's giving your legal opinion. So they've changed dramatically. As a matter of fact, one builder, major builder here, has taken out what we call the attorney's fee provision. And that is a standard in most contracts that says if either party has to sue under the contract, the prevailing party will be entitled to reasonable attorney's fees. Well, we all know that very often, and most of the time, builders are not suing the buyers. It's the buyer that has a problem with the construction or something that happened, and they need to sue the builder. Well, now they've made it more difficult in saying, if you sue us, if you sue the builder, none of your attorney's fees, and that will be a hefty amount. So let's kind of talk about the deposits and kind of what's going on there. Is a deposit deadline covered under force majeure?
So, interesting question. And I hate to give you the old lawyer answer, but it depends. There's two types of force majeure in Florida law. One, which is known as the common law, which derives from judicial precedent in cases. And that requires that performance be impossible, meaning you actually can't give the deposit for whatever reason. Banks close down and no longer accept checks, or whoever's receiving the deposit is closed. That's probably not going to be the case. So the common law is probably not going to help you out. The other is contractual. And to determine whether or not a force majeure provision will extend the dates of a deposit in a new construction contract, the answer is it depends on the contract. It's going to be up to the contract to determine whether a deposit due to the builder can be or cannot be delayed by the occurrence of a force majeure.
And one thing I want to just point out about that, because you raised a great point, Christian, is the old lawyer, it depends. And with these builders' contracts, a lot of times clients and agents think, well, I'm buying from ABC Builder, in Claremont, so the contract should be the same project for the subdivision in Orange County. What agents need to be aware of, and as well as buyers, is these builder contracts can vary from subdivision to subdivision, even if they are the same builder. And
yeah, we've seen that a lot.
Exactly.
And again, it depends too. Some may be a condo, some may be a townhouse, some may be a single family, some may be a subdivision with another division, and then there's just different standards because some of these builders have done acquisitions of other builders, and they use the builder they acquired, their original. It's very, very confusing. Getting back on the force majeure thing, as we know, and I said before, these contracts are written one-sided for the builder. So the force majeure is written for them. But so if they can't build your house because of what's going on and can't get supplies, they're probably going to be able to invoke that. If you can't, on other reasons, it's going to be hard to do. And that's something like this client we just had yesterday, he hired us to review the 60-page contract, then we're going to look at it. And I told him, without even looking at it, it's going to be hard, but we talked out some alternatives that we're going to go back to the builder with some suggestions to kind of keep the deal going. But he said, I'm prepared to lose my $20,000 deposit if they won't agree to these addendums that we want to try to help them out. I think we're going to be able to do it, but you never know. We don't know what their attitude's going to be. Question, can we do wills in other states? Right now, we're not set up for that. I'm admitted in 3 other jurisdictions, but right now we're focusing everything right here. But we can try to give you a referral. Okay, so great question now from Kim Garcia. What about not meeting new construction contract requirements to get to design center to make the selections because it's closed?
So,
now, go ahead.
So that falls to a completely different set of contract rules under Florida law. It doesn't follow force majeure. What that provision is another party can't prevent you from doing something you're required to do under the contract. If they do, that can provide you either A, way out, or B, an extension, depending upon what the contract says. It's a principle known as prevention of performance. So if a contract requires that you go to a design center to make specific selections, but you can't because it's closed, obviously that's going to either be told, or if the contract gives you the ability to exercise a different alternative.
Well, because most of the builders do have in there, you have to within 7 days, 10 days. So not only could the design center be closed, let's say the builder says, I'm in Osceola County and my design center's open. You got to get here. And you live in Orange County. Well, no, you've got an order, you can't go there. So
yeah, I was going to say one thing I'll put in there is it's really important for these agents and these buyers to also look at the cure provisions with it and the notice of default provisions, because sometimes the design center could be closed. Let's not just play the gotcha game here. We want to document your file. You want to make sure, is this a default under the contract? The prevention of performance issue from a legal standpoint. Do you have to provide written notice to the builder? If so, how? Is email going to suffice? A lot of these builder contracts don't want email. They want certified first class mail, express mail. So it's important that they contact us to see what do I do in that situation to make sure my buyer is protected. And if there's a way for my buyer to get out or proceed forward so that the buyer is not found in breach.
Right. So yeah, there's a lot of moving parts on these. And one of the things is if any buyers are listening, or viewing this on us, or also for the agents, if they want help on this, we have pretty much suspended in-person consultations. Because the safety of our staff and everyone is, even though it is an exception on here, we will set that up on consultation by phone, and that way we can still give you the advice. They can email the contract once they retain us. We'll review it and go over that. Okay. All right, so Daniel Benacourt, can sellers who don't use mail close remotely? Use email? Well, they don't have to have email, but they will, to do a RON closing, they do have to have access to the internet, because there's several platforms out there, and they're obviously overloaded right now because so many people are using them. They're at capacity. It's hard to do. But yes, they, even though you don't have to have an email account, but you do have to have an internet connection, you have to have a camera, and you have to have a microphone. There are some platforms that work on a smartphone or tablet, others don't. So it's vendor by vendor. And I tried to do a closing yesterday. They had to hold the driver's license up. It wouldn't take it. They tried doing a smartphone. It wouldn't take it. We had to abandon it. We're doing it again today on a different platform provider. These are third-party platform providers. So hopefully we'll get that done.
Barry, before you go to the next question, you and I have been receiving a heavy amount of calls about people in the service industry that are losing their jobs. With respect to the contract, are they still required to close even if they lose their job?
Well, the issue is, the lawyer answer, it depends. Now, if they already have the loan approval from the lender, let's discuss that. They have loan approval. So under the contract, technically, yes, they have to close and they would lose the deposit. Everyone kind of agrees on that.
Agreed. Yes.
Now, if you don't have loan approval and you're in and they lose their job, obviously you can cancel because you can get a denial letter from the lender. Now, the more likely scenario is going to end up happening is they're all approved. The lenders, by the way, are verifying employment right before closing. And if you do lose your job and then the lender says, well, we're not, this is a common question, they're not funding, they won't fund the loan, it's force majeure.
It's not.
Unfortunately, but here's what I'm telling people, don't crash the deal. Use the addendum, extend it out for maybe 2 weeks, and especially maybe they're in the service industry that will be back and running. Maybe give them a 30-day. Now, here's the other thing too. Your buyer, for whatever reason, can't close, or the lenders, let's say the lender. Unfortunately, we did get notice yesterday that one lender is suspending their operations for 2 weeks. So it's no fault of the buyer. They're ready to move in. They have the money. They're still working. They can't do it. Well, can they go to another lender? Yes. So maybe give them an extension to go to another lender to open up. But then they're like, well, we got to move our apartment leases up. This is where the pre-occupancy agreement will come in. So we can draft those. Under the contract, it says who the buyer or the seller is going to pay for it, or they can split it. We can draft that up so that way the buyer can get in if the closing is delayed. Or let's say the seller can't get out because they have some sort of circumstance. We can do a post-occupancy agreement. So again, there's all kinds of ways to get to yes. And as we like to say here, we like to be deal makers, and we want to find a way to get there. Got to be legal, but let's get there and let's look for resolutions.
Barry, one other option I had come up actually just yesterday was, depending on the circumstances, there's a possibility of seller financing. Seller may be willing to extend, in essence, the loan to the buyer. It could be something like a short-term loan, obviously necessitating the buyer, once everything clears, once they regain employment, to refinance and pay off the seller. But another option is possibly seller financing.
Yeah, and obviously that kind of is if the buyer, rather the seller has the funds to do that, because we have to pay off their loan. If they're only going to walk away with $10,000, that's not going to work. You got to have that money. So
the situation that arose for me was that the house was paid in full and there was no outstanding debt. So again, it's going to depend on the circumstances.
So those are good alternatives. All right, let's take a couple of other questions. Is there any reason why you don't like the standard extension addendum? Yes, you can use the standard extension addendum. It's just that ours is comprehensive and has more than just the time for the extension for the closing. It addresses the other issues like financing on there, and it's a little bit more in there. Okay, the next one. All right, so again, we just kind of went over that. What if the approval falls through in QC because job loss due to Corona? So at that point, the buyer may have their deposit at risk. And again, we'd ask people to work with each other to try to extend that so that the deal can go through.
The key to that would be ensure if you think a buyer is going to lose their job, go ahead and extend the financing contingency now. The rationale being is that after the financing contingency is expired, it's much more difficult for the buyer to get their deposit back on the basis of a job loss, which results in a denial of financing. We would recommend that you, if that is a possibility, extend the financing contingency now to give your buyer that extra time in the event their loan is denied because of that reason.
Well, it's another just important point to point out, because Barry, you brought up that we had one lender contacted you, or you were advised that they're closing for 2 weeks. Well, it's just going back to the force majeure issue, is buyers and agents need to be aware of what is truly the force majeure and reasonable abilities to do so. So that buyer may have been using ABC lending to get a loan. Just because ABC lending now is not issuing any loans, not writing any loans, that doesn't mean the force majeure provision has kicked in. They can go to Bank of America, Wells Fargo, seller financing. There's alternative areas of ways to get the deal done.
Correct, and that's why I said, mentioned before, extend it out, let them go to another lender. And let's get it done. All right, so good question from Oren. How will appraisals be handled? That's going to be the problem because under the order, it does not appear that appraisers can be out there. So right now, it looks like in Orange County, appraisals can't happen. So let's talk about that. Does appraisals kick in force majeure? Does it kick in the loan approval, which they're always conditioned upon an appraisal?
In the event there is an appraisal contingency, I'd say yes. The inability of an appraiser to appraise the property with an appraisal contingency would constitute a force majeure. It gets a little shakier when you start dealing with appraisals related to lender approvals.
Well, what's interesting is actually, if you turn to the executive order, we go to section 29, and this may be somewhat of a stretch, but architectural engineering and land surveying services are included. So here goes with the great answer, Christian. Land surveying services, the appraisers out there to, let's say it's a purchase of a vacant lot, and the bank's going out to do the survey.
As I said, this is fresh on there.
Yep.
Well, I will tell you one thing that I will be doing after and today is sending an email to my contact at Mayor Deming's office that I've worked with and asking for clarification today on appraisals and ask them to add to number 29 to add appraisers in there so appraisals can keep going. It may have just been inadvertently left off. Let's hope so. I think they'll react quickly to it. And I think since they did put these other services in there, it could. Now, it could be a stretch too. It says banks and related financial institutions. Is an appraisal related to the financial institution? Yeah, you could argue it is. So there's a little gray area. We're going to ask them for clarification. All right, another question is, can a notary go to the seller or buyer's home since housing is considered essential services? Not because housing is an essential service, it's because legal and accounting service and notaries public. So since notaries is specifically in number 20, notaries can provide services and they are exempt. All right, so let's talk about now the last topic is evictions, because before this executive order even came out, the sheriff of Orange County and some of the other counties have said they will not enforce writs of possession. So as you know, this is how it works. You file against, you got to do your 3-day notice, then they get served with a complaint. They have 5 days to file a response. If they don't answer, then we request the clerk of the court to enter a default, and then we request to have a writ of possession issued. The writ of possession is then delivered to the sheriff's office. Then normally the sheriff will go out to the property. They post a sticker on there saying they're going to be back in 24 hours. If the person's not gone, they will be removed. So the sheriff said they will no longer be serving writs of possession. So what's our advice to our property management folks and landlords? Should you just not file your eviction and wait until it's going to be, the sheriff will start serving them?
So let's talk about that, because I've got a bunch of calls coming through recently where people are under the impression that rent has stopped accruing for some reason. There's nothing out there that can stop rent from accruing under the lease without the landlord's consent. So rent does tend to accrue. It's still accruing. Even if the tenant isn't paying you and you can't kick them out yet, the rent is still accruing and you can sue for the difference later. The fact that the sheriff has stated that they won't serve writs of possession does not stop the actual filing of an eviction. And in fact, I recommend doing it now. The rationale being is the courts are still open. They're working at somewhat reduced rates or working from home. So things might be delayed, but do it now. File the eviction, tee it up, get through to the writ of possession process. The clerk of court will issue the writ of possession. The sheriff just won't serve it. I've spoken to the sheriff of Orange County, and they've told us that once they resume evictions, that they will be filing, or rather serving, those writs of possession in the order in which they were received. So filing your eviction all the way through to the writ of possession now will save you some time later. Obviously, there's going to be a backlog at some point when the sheriff has 2, maybe a month's worth of writs of possession to serve and only a limited staff in which to serve it. So get it in now, be on the top of the list, and it'll save you some headache in the future.
Yeah, we've gotten a lot of questions, people thinking, well, just, and I've actually had some of my tenants call me saying, oh, so is rent going to abate? I'm like, well, my mortgage company hasn't abated my mortgage, so no, rent's not going to be abating either. But again, let's look for a roadmap to resolution. What we recommend is talk with your tenants, work something out with them. And everything should be in writing, signed by both parties. And this is something that we can help you with and draft an addendum to meet the needs. It could be, I think, Robert, why don't you address, there's a couple of different alternatives that we could put in there and suggest to try to get this done, and again, try to work with people.
Yeah, I mean, you want to keep those tenants in place as long as possible, because that stream of income coming in. Yeah, people are having difficult times right now, so we have received a bulk of telephone calls from landlords and as well as tenants saying, hey, well, how do we address this rent issue? If the relationship between your landlord and tenant is a positive one, there are alternatives. And like Barry said, you want to make sure it is in writing. Because if you have a written lease in effect as of right now with the tenant, the lease probably says 99 out of 10, 100 times that the lease can only be amended if done in writing and signed by both parties. So what we have done is we brainstormed as a legal team is what are the possible solutions on rent? And there could be a rent reduction for a certain period of time. So the rent's, $1,000 a month, maybe it gets reduced to $750. So that rent reduction of $250 per month may go into effect if agreed upon by the landlord and tenant. Now, what do you do with that $250 is the question. Now, that's where we've come up with different solutions. One option can be that the landlord and tenant agree to waive it, in this period of time for 1 month, 2 months, 3 or 4, whatever the parties agree, that the landlord has agreed to reduce the rent to $750, and then it will go back up to $1,000 on X date. Or the parties can make an agreement that the reduced rent will be paid back over the remaining term of the loan, or that the landlord has the right to take it from the security deposit. And that's a big thing when we're talking about the security deposit, because a lot of times landlords have 1 to 2 months in reserves as a security deposit. And to protect the landlord, you want to make sure that the amendment to the lease accurately reflects what is being done, so that the tenant at the end of the lease doesn't try to make a claim or a counterclaim against the landlord, saying the landlord did not handle the security deposit properly. And that's probably the best way for the landlord to recoup the money, is to take it through the security deposit. But again, it needs to be done in writing and with the proper wording.
Yeah, absolutely. And for those landlords that are like, well, wait a minute, if they don't pay me my rent, I can't pay my mortgage, and I'm going to be defaulted. So that's a great alternative, to have something in writing that will say that the landlord can use the security deposit maybe for next month, and then somehow the tenant will replenish it maybe in smaller monthly extra payments to do it. Or if they can't make this month's payment, agree that starting, let's say in June, that they agree to make it up then. So that we can tailor it any way to make the deal work with people. You've got to try to work with people. It's horrible if someone has lost their job. It's the last thing is someone should have to be evicted. We want to please try to work them. Your property managers, try to do that with them. There's great alternatives that we can help them with that. So let's take some more questions. We've got Kim Hogan. What if buyer had loan approval for jumbo in the loan product, then due to the current economic environment, investor decides not to move forward and declines? Can buyer cancel and get their deposit back? So that goes back there. If they had loan approval and then your lender says we're not offering this or we're shutting down or whatever it is, no. The buyer would lose their deposit because they have alternatives. They can go try to get it somewhere else. Again, we would suggest if something like that happens, give the buyer an extension, shop for another lender. If they've been approved with someone else, they still have their job, they're probably going to be approved on another. Bethany Lear asks that, she says, NAR has appealed to consider real estate an essential business. I've read that there are some states, counties allowing and others not. Any idea if there's been a ruling in Florida? It's not a ruling. So the Florida Land Title Association and the Florida Realtors sent a joint letter to the governor, Governor DeSantis, saying if he puts a stay-in-place order to exempt realtors as essential. The governor has indicated at this point he's not putting one of those in statewide. So county by county, as we discussed earlier, it does not, realtors are not, and real estate agents are not exempt as essential. So at this point, you can't be showing property in Orange County. Okay, next question. Can we summarize who can or cannot go out as part of real estate transactions?
I've posted the emergency stay-at-home order in the group chat. There's a list in the order of what is considered essential and what is not.
Right, so we've kind of gone on that, but in essence, right now, appraisers cannot, inspectors cannot, movers can, notaries can, but legal services, you can go out for that. Okay, as a tenant whose lease expires March 31st, notices were given for vacating. However, now they will not be moving. Do you need to write up a new lease? All right, that's great. Great question. So in essence, since their lease is over, you've got two options, right? One is
Holdover.
Well, one is if they just stay there, under Florida statute, the landlord's going to be entitled to double the rent. So I'm sure no one wants to take advantage of people at this time. So there's two things. One is they could become a month-to-month tenant. So, and again, I would do something in writing, signed by both parties, saying that the contract is extended. So to say that way all the terms and provisions apply, because technically that lease is over. And it could be some things that have certain obligations that are different from the statute that would change. So we want to keep the continuum. An addendum, and again, realtors cannot draft these addendums. It is the unlicensed practice of law. Under the Florida statute, you guys can only fill in the blanks on the approved Supreme Court lease, which I don't recommend. I think there's lots of problems in there. So they should extend the lease, and then you can say, we can extend it for 3 months. We can extend it month to month. Any other suggestions?
Well, one other option, depending on what's in the lease, for example, in the lease that we prepare, we have an automatic renewal provision with a acceleration or increase in the rent. So in the event you are utilizing one of our leases or you want to utilize one in the future, again, it's already addressed in the lease. It automatically renews unless the tenant provides written notice in the alternative.
Yeah, and one thing just to piggyback on what Barry and David, what you're saying is, it's really important that these agents contact us if they're drafting an addendum to the lease or want to draft a new lease, because we've handled, I think all of us now this year alone in 2020, in the last 3 months, we've had a couple of cases come in where landlords have pointed the finger to their agents saying the lease was not drafted properly, and the landlord's not happy with their landlord and has filed claims, whether it be before the regulatory regulatory boards or the court system, and we've had to be retained to represent these agents to protect them. So it's really important that agents, contact us because they want to make sure not only is the landlord protected, but that they themselves are protected with it.
Yeah, great point. And we just did, one of the things is be careful, as those of you who do a lot of leasing and property management, and I had an agent last month that says, oh, this is the lease I've used for years. For years. I've never had a problem. Except for now when it came up, because the landlord-tenant statute changes almost every year. We're going to see what the legislature just finished up. There may be some changes, especially with notices that you're required to give for the security deposit, things like that. So we always recommend, if you're doing property management, we can do a standard lease for you, and then every year we give you a notice and let you know that it needs to be updated, and it's very, very affordable for stuff like that, and it's a great, great way to do things and save yourself, because believe me, people like to point fingers when things happen. All right, let's see here. Okay, this question, scroll up a little bit, who is, okay, my customer, the buyer, is enforced to sign the Corona addendum to the seller. New construction buyers need to extend an extension for 7 days from 7th due to the buyers. Unfortunately, they did not accept the Florida Realtor addendum form and will continue to charge the penalty as per diem. Okay, so I think what I can clear from that is they have new construction closing on the 31st. They can't close. So yes, most new home constructions do have something in there that says you pay $100 a day, $200 a day. Again, now you're dealing with big bad builders. That's horrible that they needed to extend it for a few days and they're going to charge them the addendum. They're going to charge them that daily fee. So unfortunately, we can see if there's anything else in the contract and see if there's any way to do it. Sometimes we get those extended because the contracts say they have to give the buyer a certain amount of notice. We had that on one recently where they were trying to force our client to close, and we said, hey, did you get a notice? And they said, yeah, they sent me an email, and the contract said the notification had to be given a different way, and we said, you didn't do it right, so now you got to do it, and now we get an extra 7. So we actually got them an extra couple of weeks because of it. So, but it's really disheartening that these builders are taking this hard line. Have there been any other orders for counties surrounding Orange? As of 9 o'clock this morning, no. I don't know what's happened since we've been on. I fully do believe that Osceola will come on very quickly. I think Lake will probably come on too. I believe Volusia has been talking about it in Brevard, especially Brevard because of the beaches. In Volusia, Seminole County have not heard anything yet whether they're even considering it. So again, when these things come out, we'll update. Always check our website, theclosingagent.com/CV. Okay, let's take another question. Vera Vargas, good morning. If other housing providers are included in the stay order, why are real estate agents not able to do showings with precautions? What about final walkthrough?
So it's section 2B4. Ariel, I think you might be stretching that a bit. Real estate agents don't provide housing. They provide a listing and selling service. Now, what else could qualify under that section? And Barry, that's section 2B4 on page 3.
So let's just say it says businesses that provide food, shelter, social services, and other necessities of life for economically disadvantaged or otherwise needy individuals, hotels, motels, and other housing providers. Yes, we don't provide houses. The seller provides them, builders do. Great try to stretch of it, but I don't think that's the intent, especially when it's grouped in that paragraph with food, shelter, social services.
Yeah, the court's going to construe, like you said, Barry, the court's going to construe that paragraph in its entire context. And hotels, motels, the court's going toward that direction, not the sale of real property.
So what else would qualify as other housing? I'm going to say campsites potentially, RV parking potentially, and things of those nature, not the actual providing of a service to sell real estate.
So let's take that a step further. Does the leasing office in an apartment complex open or closed?
I would say open under other housing providers because they are providing housing. They are providing the leasing of apartments, or now that, just so we get this clear, this does not, even if someone's essential, does not mean they can't make the decision in and of themselves to close.
So, what Onira said, what if you're a property manager that rents out property and a tenant calls and says, I need a place to live. Can you, I see you have a listing for this house for rent. Can you show it to me?
That I think would qualify because then in that instance you are providing a housing service as opposed to a listing or cooperating broker side. You're really not.
It's a fine line. Now maybe you can say, well, I'm going to offer you a lease with option to purchase. that'd be stretching it, but it'd be getting creative. Okay. Okay. Arena Paul. I have closing on May 28th, and my sellers might need to stay in the USA and ask for a post-closing occupancy. Buyers are open to that. Suggestions on how to handle it. Well, just as we said before, use the addendum for the pre and post. Get in touch with us, and we can draft that and just decide who's going to pay for it on that side. Be very careful. I had a month ago an agent that said, no, my seller is not going to pay for this. I went online and I drafted one myself. Okay, and I looked at it. It was not good. I informed that agent's broker that she could be turned into the Florida bar for unlicensed practice of law, and please don't do that. Stay in your lane, guys. You don't want something to come back and haunt you because, as Robert said, some of these people, if something's wrong in there, they'll go and sue you. Someone gets, you didn't put an insurance provision, someone gets hurt, they'll be making a claim on your insurance.
Yeah.
Other question too, when we're talking about the rentals with landlords, if they can't get rent, could they make a claim on their business interruption insurance that they may have?
Well, the business interruption now has become a really hot topic. You've seen it on the news. A lot of businesses do have business interruption. It depends on what the policy says, because a lot of policies don't cover pandemics, epidemics, viral diseases. So there's a lot of issues out there. A lot of attorneys now are trying to make a niche business in that segment. I'm filing with almost like a first-party claim by the insureds, which is the business, against the insurance companies. But it would have to depend policy to policy. I would probably say it's probably not covered, but it depends on the policy.
Yeah, and as we many of you know, we do represent a lot of businesses and represent small businesses and get them set up. So we have looked at a few policies and for clients, and a lot of them did have that exclusion. So again, call your agent. And I wouldn't rely on the agent. I would actually if they say no, ask them where exactly in the policy does it say it. For all of us that don't read our policies, now's a good time to do it. We're at home, got something to do, need something to do, take a look at your policies.
Jumping topics real quick. I've seen 2 addendums now extending the closing date until the coronavirus ends. Please don't do that. You're extending for an indefinite period of time, and who knows if the coronavirus is ever going to end.
Yeah, because what is end? If there's one case in the U.S., in the county, in the state, is someone going to declare its end? Please don't do that.
Pick a date certain if you're going to extend.
Yeah, or have something other. Definitive terms. All right, can you please clarify how the buyer should access a property, and if they are exempt, does the contract suffice for documentation if they were pulled over? Again, that's why we said earlier, if you're coming to closing, we will, from your processor, give the people, email a letter. So if they are on their way to closing and they go to the property to do their final walkthrough, they should be okay to do that.
And what's important to know is that they should be okay, but does not guarantee they're going to be pulled over. That cop can disagree with our letter and our legal position. Like Barry said at the beginning, this order just came out less than 24 hours ago. There's going to probably be different revisions. We're going to try to contact our points of contact within the county and at the city to receive clarification. So it is going to be on a case-by-case basis because there is some ambiguity with this emergency order.
Okay, the next question, which is a great question, how does Orange County order apply to county inspectors going to give final inspections in COs? Well, one of the exemptions in here
Section 2,
is,
subparagraph C.
yes. On page 5, this order does not affect or limit the operations of Orange County. Now, whether they're actually going to go out or not, that's going to be the inspector's office. They may make a determination. So technically it's open, which brings up another point. A lot of people have said, what if the Orange County comptroller closes? What happens if they say we're working at home and we can't do e-recordings? I did have this just on Tuesday. We had a client that is building new townhomes. We had the declaration that had to be recorded. Declarations of HOA or condo cannot be done due e-recording. It has to be dropped off. We had to get a certificate from the appraiser's office and the tax collector. Luckily, I called them. They were working remote. They emailed, we had to pick up the original. They left it for us, so we got it picked up. But now we couldn't record. So I contacted Phil Diamond's office. They don't have a drop-off box. They don't have a slot to put it in. But we were able to overnight it and it got recorded. But what happens if, Seminole County or Osceola, the recording office closes? Can we close? All right, the answer is depends on where you're trying to close. We can close. Our underwriters have stated that even if the recording office is closed, we can continue with it, and we will insure the gap period. The gap means from the date of closing to the date of recording. So if something gets recorded before our deed, your title insurance policy will cover it. I will let you know that there are other underwriters out there that have said no, they will not allow the closings to occur. So just be aware of that. Okay.
And that's just actually a great point, though, with the gap coverage, though. If you're closing somewhere other than the closing agent, it's really important that that agent contact the other title company to verify is their underwriter covering the gap. Because if you're representing a buyer, you're doing a disservice to them. So it's really important that they bring the, see if the policy, if the closing can be moved over to the closing agent, because then we can provide a better service and protect that buyer for that gap period. Because there could be potential claims there, and your buyer is going to turn to you as the agent and point the finger if something does go wrong in that transaction.
Another consideration on that is, oftentimes it can take a week, 10 days for a deed to get recorded. Now, in these times, obviously there's delays involved, so that gap period is unknown. It could be up to a month.
Now, one thing that we've done for years is the standard exception on the every title commitment that comes out. The gap period is an exception on the policies. However, we've made a business decision from day one, almost 30 years ago, that we are going to delete that exception without you even asking. If you're going somewhere else, I would insist, and don't if they say verbally, oh yeah, we'll do it. You have to mark up the commitment, tell them to write it on there for your buyer and initial it. That they put a big D or the word delete and make sure it can be deleted, because otherwise it's not going to happen. We had one where it was deleted, marked up title commitment, the policy came and it wasn't. And when I called them about it and say, are you really going to make me change that? And I said, absolutely, fix it, issue an endorsement. All right, let's take another question. If I can't perform a final walkthrough due to county stay-at-home closing delayed. No, because you as the agent don't have to do the walkthrough. It can be done, as we talked about before, the buyer on the way to closing. if notaries are exempt and they are an active licensed realtor, can they help other realtors out with a walkthrough? No, because it has to be doing your notarial services. Just because you're a notary doesn't mean you can go out and do whatever you want. Just because we're attorneys doesn't mean we can do whatever we want. It has to be associated with providing that service. So yeah, don't try to do that, because I know a lot of agents are notaries. Now, if you're going somewhere to notarize a document, then yes. All right, next question. Can I inquire at the mayor's office concerning a better qualification of other housing exemptions and inquire for agents considered to virtually show houses final walkthroughs? Well, we don't need to have, well, you're saying if the agents can go and if do the virtual walkthrough. I will ask about that. Thanks, Nick, for that. We'll inquire when I do that and when I ask about the appraisals. Okay, we went a little bit over from what we had, and we got some more questions coming in. So let's ask that. Any other thoughts, guys? Were any other calls we've been getting in the last few days? And everyone, please, in the industry, be patient with all the providers that are out there in trying to make this happen. One of the things we've done is our employees come first. A lot of our people are working remotely, but we're getting everything done. Everything's, the closings are all happening on time. And we're going to keep this moving, but everyone work as a team. Brian's got a question. How is the buyer getting access to the property without the agent at the final walkthrough? Right, that's what we talked about earlier. This is a problem, because if the house is vacant and there's only a lockbox on it, so in that case, if the seller can bring us the keys, because we'll need them to give to the buyer at the closing anyhow, the buyer can come by, pick them up in order to do that.
So I think, Barry, after looking at the force majeure provision, I do believe it would cover the inability to access the property to complete a walkthrough prior to closing. I do think that it would...
Is it an essential service?
But it says any obligation under the contract that's delayed or disrupted because of it.
Well, does it say the walkthrough may or must?
It says may.
Right. So, again, this is all brand new, folks. But yeah, let's not try to get to the nitpick of it. Let's figure out a way to get it done. So if we've got to get the keys over to do it, your buyer will have that letter that they're on their way to closing. So I think it should be okay. Next question, Caitlin. Any insight on how grants and state programs like FHA, HANDS program are working right now? Right now, FHA loans, we don't see and haven't heard of any interruption. HANDS, we haven't heard any either. So, because the government offices are still open. So, so far it's still going. Another question is, okay, the letter. Okay, so one of the agents is writing, where can I get the letter for the closing driving? We cannot give one to you as the agent. Okay, we can only give it to the buyer or the seller. Ask your processor who's handling your file. We'll have that they can email to the client. If they say they don't have a printer, bring it up on their phone to show the law enforcement officer that you'll have that letter. And again, the agents can come to the closings virtually, either FaceTime or something similar, or just through the speakerphone, so we can go through and make sure everything is good. So one of the questions too. Oh, I'm gonna get another one here. Okay, great question. Daniel Benecourt, have you been experiencing issues with municipal or HOA estoppels? HOA estoppels, no, because right now those property managers are either in their offices or a lot of them are working remotely. I would say a good big chunk of them. So we haven't had any issues with that. Municipal lien search, we just got a memo yesterday on that. So far so good. There are a few delays. A lot of them that are online or we have access to it, it works out very well. Some of them that are a little bit behind the times and they actually have to send a check with doing it, yes, those are being delayed because they don't have a lot of staff there. So that's a great question also. All right. Okay, so Aiken has a question, any guidance on safety conducting in-person closings or notarizations? Absolutely. We are observing the social distance. As you can see, we're all 6 feet apart, and we have our sanitizer, and we are doing that at closings. When you come in to our office, we are not sharing pens. The people are given a pen and told to take it home with them. All closing rooms are sanitized after every closing. Our closers are wearing gloves and for protection. So they are at the other end of the table. So we are observing all of the CDC requirements because everyone's health and safety is the first concern before anything there.
And we're also just asking that the agents and the lenders, not be in the closing room at this time. Just
Right
to get
now
the
in
social
Orange County, they
distancing.
can't.
Exactly.
So, but even before that,
And
we were telling people, and we're also telling people too, that only signers should be coming to closing. Don't bring your relatives, it's for their own safety. They shouldn't be out. We need to observe this order and as it expands. The next question, I have a buyer asking me if construction will be halted or if it is considered essential. Great question. They are considered essential.
28 on
It is
page
under
5.
number 10,
20.
licensed contractors, and also
28.
under number 28, which just says construction sites irrespective of the type of building. So new home building, it's going to happen. Now, will things be, if force majeure come in, because the builder may say, well, due to the trucking industry issues and slowdowns, they can't get materials. So that would be, so let's talk about that for a second. Under the Interstate Land Act, the builder has 2 years to build a home. What happens if they say, well, I couldn't get supplies, now it's going to be delayed, it could be 2 years and a month. Can the buyer get out of the contract?
Well, it's an interesting question because did force majeure actually come into place and prevent the builder from moving the project forward? If so, and if the builder can get a declaration from the court saying, yes, there was force majeure, then the contract is delayed for 2 years, 1 month, and the buyer's going to have to close then. A lot of builders, a lot of agents actually come to me. It's very common. Agents don't realize that most of these builder contracts have 2-year provisions. A lot of times these sales centers will tell the agents and to the buyers, your home will be ready in June, July, August. I have this all the time. We see a huge surge in our business right around the summertime because families want to move in and the home is not ready for the new school district for the kids. And buyers are coming to us saying the home is not ready. They said it would be ready for June. Well, it's 2 years from the date of contract. So, force majeure right now, hopefully this thing dies down, but nonetheless, it's not what they told you in the sales center, it's what's in the contract, which is likely 2 years from the date of
And
signing.
during the Great Recession, that's how a lot of buyers were able to get their money back because these builders couldn't finish them within the 2 years because the subdivisions just started failing. But I don't think that's going to come into play in today's situation. At any point, does the recording clerk office shut down? What would stop closings? So I think we just addressed that. Even if they shut down, we're still doing closings. We're still insuring them. We'll be issuing a full policy with the gap coverage. So that's great. Next question. Buyer lives in Hawaii, can't fly to Orlando for the final walkthrough and closing. I can't perform the walkthrough either. An addendum to extend until April 9th is the choice here.
So unreasonable transportation delays are set out in the contract itself as what constitutes a force majeure. I would still recommend doing the extension addendum probably past April 9th. I certainly don't have a crystal ball, but I imagine it's going to be extended. if this continues to spread in Orange County. What I would recommend doing is extending it, notwithstanding the fact that it does technically constitute a force majeure under the contract.
Well, the next question becomes, though, this agent saying the buyer can't fly from Hawaii to Orlando. And the reason becomes, why? Are the flights shut down? He doesn't want to, because as far as I know, the interstate travel has not been shut down.
Right. If the buyer just can't fly because they don't want to, then force majeure probably would not come in. But yes, do an addendum to do that and to extend it, and that would be the most reasonable solution.
And we can also do a mail away.
Right, but their concern is that the walkthrough, they really want to do the walkthrough. So, the other option too might be is if the seller's still there, to do a FaceTime walkthrough. If the seller's still there. A lot of people, I understand, will feel uncomfortable and won't want to do that. All right, the next question is, how do you get 2 witnesses to sign if there's only one person there aside from the notary? I'm not sure where there is, but if they're closing here, we do have witnesses in our office. We have staff that will act as the second witness. If it is online, we're doing an online closing, the witness can either be here while I'm notarizing them, or the witness can be with them at whatever location they're at. So that's the nice thing. It's very fluid that way, and it's easy to do. So great question on there. So there's lots and lots of information out there. There's lots of issues that come up. I want to thank everyone for attending. We are going to look at this as everything keeps changing, keeping you informed. We want to keep you updated. First thing, folks, is be safe. Follow the CDC guidelines. Follow in Orange County the guidelines that the mayor has set forth, and as the other counties come online, please do that. Try to stay home if you can, so that we can try to overcome and the spread of this, and that way this whole pandemic will end sooner. We want to make sure everyone's safe, but be reassured, we're here for you. We're still closing, and we're still keeping real estate moving, because a big part of our economy is in this area is for real estate, and we want to keep sure everyone stays in business. So again, thank you, and be safe.